The committee will come to order without objection. The chair is authorized to declare a recess at any time pursuant to Committee Rule 2, House Rule 11, Clause 2. The chairman may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. I now recognize the gentleman from Maryland to lead us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Pursuant to notice, I call up H.R. 7137, the Trafficking Survivors Relief Act of 2024 for purpose of a markup. Move that the committee reported favorable to the House. The clerk will report the bill.
H.R. 7137.
Without objection, the bill be considered as read and open for amendment at any point. The chair now recognizes the gentleman from South Carolina, Mr. Fry, for an opening statement.
Thank you, Mr. Chairman. The bill we're here to discuss today, H.R. 7137, is a strong bipartisan, bicameral piece of legislation that will help combat human trafficking across our country. I would like to thank my colleagues who are here in this room on both sides of the aisle for coming together and co-sponsoring this legislation that we aim to move forward. Human trafficking, specifically sex trafficking, is a heinous crime that tragically continues to grow in our country. While international sex trafficking may be more widely known, domestic sex trafficking also persists in the United States. In fact, Horry County, where I live, and one of the counties I represent, is one of the top 3 counties in the state of South Carolina in reported human trafficking. Human trafficking can occur anywhere. Traffickers can even use social media to lure innocent people to becoming victims. Women and children who make the dangerous journey to cross the southern border into the United States have a high likelihood of being trafficked. A study by the Coalition Against Trafficking in Women estimated that 60% of unaccompanied alien children are exploited by cartels or smugglers for child pornography and drug trafficking. In the United States, an adult or child can be trafficked and exploited at hotels, truck stops, their own homes, and online. Trafficking victims are exploited in cities, suburban, and rural areas. It can happen anytime and anywhere. Efforts by federal, state, and local law enforcement and advocates to eliminate human trafficking and support victims have increased awareness, reporting, and prosecution of sex traffickers across the country. However, victims of these crimes are sometimes prosecuted for their actions while under control of their traffickers. Traffickers use force, fraud, and coercion to induce their victims to commit crimes. This can lead to the arrest, conviction, and incarceration of trafficked victims without consideration of their victim status. Things like getting a job, voting, and renting an apartment can all be impossible to do if victims of human trafficking have a federal criminal record, which can happen as a result of being trafficked. Thankfully, we as a country have made significant progress to help victims and survivors move forward in their lives. The vast majority of states actually provide some sort of relief to victims for nonviolent offenses committed while under control of their traffickers. These laws allow victims to move on from these horrors, re-enter their communities, and get on with their lives. My own home state of South Carolina, in part due to the leadership of our Attorney General, Alan Wilson, continues to lead on this forward victim-centered approach. The Trafficking Survivors Relief Act follows several states' clear lead and provides federal relief to survivors of human trafficking who have committed nonviolent offense as a result of being a victim of trafficking. For a court to grant a motion to vacate a conviction or expunge an arrest, a defendant must show by a preponderance of the evidence that the offense was committed as a direct result of having been a victim of human trafficking. Additionally, the defendant must establish by clear and convincing evidence that the defendant was a victim of human trafficking at the time the offense was committed. To ensure that these opportunities are only available to true victims of trafficking, the legislation allows for additional evidence to be considered, including the sworn testimony of a law enforcement officer as to whether a victim had any role in coercing other victims into criminal offenses. This bill would restore trafficking victims and reintegrate them into their families and their communities while making sure that law enforcement and the courts can protect public safety. This legislation is endorsed by numerous advocacy organizations and law enforcement officials. Multiple attorneys general, including in the states of South Carolina, Georgia, Ohio, Tennessee, and many others, wrote in support of this legislation. Simply put, this legislation strikes the right balance between victims' rights and public safety. Let's work together to fight back against the evils of human trafficking and help the victims and survivors move forward with their lives. Mr. Chairman, I also want to thank this committee for this markup. And the incredible bipartisan support. When you have conservatives like me and Andy Biggs and people on the other side of the aisle like Sheila Jackson Lee and Ted Lieu, coming together on an issue like this. You know that it's important. And with that, Mr. Chairman, I yield back.
Gentleman yields back. The chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 7137, the Trafficking Survivors Relief Act of 2024, is important bipartisan legislation that would provide relief to human trafficking survivors who have been unjustly criminalized because of acts they were forced to commit by their traffickers. Far too often, trafficking victims are arrested and convicted of crimes that are the direct result of their victimization. This legislation provides a remedy for this injustice. I am proud to be a co-sponsor of this bill, and I thank my colleagues in the majority for bringing this bill to a markup. Although we do not agree on much, I'm grateful that we can join forces to protect trafficking victims by bringing about much-needed criminal justice reform. Human trafficking is a multi-billion-dollar criminal industry that takes the freedom of nearly 25 million people around the world. Traffickers exploit their victims by forcing them, through violence, fear, and manipulation, to provide labor, services, or commercial sex acts. Traffickers often force or coerce their victims to commit other crimes too, such as money laundering, drug trafficking, robbery, theft, and prostitution. This leads to trafficking victims being arrested, detained, convicted, and sentenced without consideration of their indisputable status as victims. They are then made to serve prison sentences. They are left with criminal records that can prevent them from getting a job, finding housing, and even getting the treatment they need to recover from the trauma of their victimization. Although 35 states allow trafficking victims to vacate convictions resulting from their victimizations, there is no federal counterpart. H.R. 7137 would fill this gap by allowing human trafficking victims to petition the court to vacate convictions for nonviolent conduct committed as a direct result of human trafficking, and to expunge the record of arrests for nonviolent conduct directly related to their trafficking victimization. These post-conviction remedies are available only for offenses that do not involve child victims, with the exception of allowing for a motion to expunge an arrest for an offense involving a child victim or for a violent offense if the charges were reduced, dismissed, or otherwise disposed of. In addition to post-conviction remedies, the bill also provides an avenue of relief for trafficking victims who are facing ongoing prosecution for certain federal offenses relating to their victimization. Specifically, it creates a rebuttable presumption that the charged offense was induced by duress if the defendant establishes by clear and convincing evidence that they were a victim of trafficking at the time of the offense. This provision will give trafficking survivors the opportunity to avoid convictions for conduct for which they should not be criminally liable. For far too long, we have closed our eyes to the very nature of human trafficking, that it creates a cycle of crime in which the victims are treated as perpetrators. We must do better. We must do everything possible to prevent victims from being re-traumatized by the criminal justice system. And we must give trafficking survivors the resources and the support they need to heal, rebuild their lives, and rejoin society as the productive warriors we know them to be. The Trafficking Survivors Relief Act is a crucial step towards that goal, and it is long overdue. I thank Representative Fry and Representative Lieu, along with Representatives Wagner and Garcia, for sponsoring this legislation, and I urge all of my colleagues to support this bill. Thank you, and I yield back.
Gentleman yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from South Carolina for the purpose of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered the base text for the purpose of amendment. The chair now recognizes the gentleman from South Carolina to explain the amendment.
Thank you, Mr. Chairman. This amendment strengthens the law enforcement protections by assuring the court has the option to consider sworn testimony of a law enforcement officer of whether the victim of human trafficking had a role in coercing other victims into criminal offenses, and I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from California is recognized.
Mr. Chairman, I have no question. Human trafficking is just terrible, and it's become rampant as a result of the open border policies of this administration. In fact, we just received word that some 150,000 children trafficked into the United States by our own government have simply disappeared and are likely now the victims of human trafficking. But the question I'd like to ask is, isn't that a mitigating circumstance that the prosecutor should determine and the jury should decide? I would assume that if someone's being coerced into an illegal act, that would be a defense they would offer at the trial for the jury to decide. Doesn't this take this determination out of the hands of the prosecutor and jury and judge and place it in a form that doesn't offer both sides to be heard? If anybody could answer that question for me, I'd be very grateful.
Does the gentleman yield, the gentleman from South Carolina? Gentleman yields, I think, the gentleman from South Carolina.
Thank you, Mr. Chairman. Mr. McClintock, 30-plus states have this, and I think that when I served in the state legislature, the importance of this was that it, and why prosecutors particularly like it, is that it allows a victim who oftentimes won't talk about their circumstance. When they are incarcerated, they get out of jail, oftentimes they go right back into the world in which they left.
If the prosecutor is accepting that as a defense, why would the individual be prosecuted to begin with? This takes it out of that forum and places it into a separate one where both sides aren't being heard and the prosecutor isn't being heard.
Well, because the prosecutors often don't know, and that's why the importance of this bill is supported by both victims' rights organizations and prosecutors.
But again, this would be a defense that would be offered at trial, would it not?
It's not a defense if it's not in the law. So this provides that affirmative defense in statute that if they come forward and they can prove it.
No, but if the prosecutor decides that the individual is culpable and should be prosecuted, and the jury, it goes to a jury, won't the jury make that determination, and isn't the jury in the best position to make that determination? Was the individual coerced? If they were, then they're not guilty.
So oftentimes trafficking victims are picked up for things like prostitution or other nonviolent crimes, and so it's not a situation where they're picked up and charged with trafficking if they're actually a victim of trafficking. It's other things, and again, this provides that affirmative defense. It allows, and this is why prosecutors again like it.
But again, that affirmative defense is available at the trial if charges are actually brought. And if charges are brought, it's because the prosecutor has recognized this individual was acting in performance of a crime.
Well, again, I think I look at it, surprisingly, we don't have this, but 35 states have led on this. And I think it's important to have that affirmative defense spelled out in the law. And again, I think that's why you see it bicameral, bipartisan. You have victims' rights
I understand.
organizations
I understand. Everybody loves it, but I'm just trying to understand why that should be taken out of the hands of the judge and jury.
I don't think that it does. I mean, I would disagree with you on that assessment that it takes it out. Again, I think it provides very clearly within the law, if this were to become law, that victims of human trafficking could tell their story, that they could prove that they are a victim. And again, the entire purpose of this is to take nonviolent offenses and charges against oftentimes women and allowing the prosecutors and the law enforcement officials to go after the real people, the real perpetrators who are
But they have that
continuing this
authority.
cycle.
They have that authority right now.
Not if people are not talking or sharing their story.
Well,
That's why this is important.
If someone is charged with a crime, I would think that they would say, I was forced to do this, I didn't want to do this, and the prosecutor is probably going to say, we can't prove this to a jury, and the jury, if they hear it, is going to say, we're not going to convict this person for something they were forced to do against their will.
Will the gentleman
In my-
yield for
in
a
my-
question?
Yeah, but please, I'm
Can
just...
I respond real quick?
Yeah, I'm sorry.
Mr. McClintock, and happy to have you come in. When I talk to victims, both at the state level and here on this particular bill, there is a real hesitancy to coming forward and telling their story. Oftentimes, they don't view themselves as victims of human trafficking, and so if we're providing an outlet, this allows them to provide or share their story to get these charges expunged and dismissed. It's important because, again, victims often don't see themselves as victims, but if you can prove by preponderance
So they
of the
won't come
evidence-
forward at trial, but they'll come forward
True.
after trial.
Yeah, true.
Gentlemen, the time the gentleman has expired. The chair now recognizes the gentleman from Maryland.
I'm trying not to take the bait on this one, but just to be clear about it. So I appreciate the question, but the step you're skipping is before trial. So when the prosecutor's trying to put the case together and he needs witnesses who will testify against the top fish at the top of the food chain, he goes to the bottom fish to testify against the top fish. And that makes sense for two reasons. One is the top fish is the one that's actually creating the major problems. So if you prosecute the bottom ones for prostitution even or something minor, or if they've been pressed into doing higher level criminal activity, like say money laundering, we take them out, but this guy keeps going. That's the last thing we want here in the United States. So what prosecutors do is to put the case together, they cut deals with the people at the bottom of the rung. Think about the
But that all happens at the
Pre-trial.
trial level.
pre-trial.
Yeah,
not trial. There's
why
no
would
trial
this-
if you don't have witnesses.
Why would this bill be necessary? And again, I'm looking for an education in this. I don't understand what the rationale here.
Right, because you want to make sure that the person who is going to be the witness has assurances. I mean, they need an incentive to do it. We're not trying to create a
Well, then they
scenario
wouldn't
where
need to have the charges vacated later, would they? Because the charges would never be brought, there'd be immunity.
if I'm a defense lawyer, there's no way I would go have a witness go forward or a client go forward without cutting the deal up front on a
Right.
promise to vacate down the road.
Which
Wouldn't do
makes this
that.
bill unnecessary.
Wouldn't do that. So you want to try and do it in advance if you can. Sometimes if you go forward and they've prosecuted them already, then you would need to vacate. But normally the way you want to do it is you want to create the scenario so the witnesses that you're going to need to get the top of the food chain, you want to create every opportunity to make them available.
Would the gentleman yield for a question?
Yes.
So in my experience, that doesn't come from an affirmative defense. That comes when my client is being charged with something, and they believe we can offer them something. So they don't say, well, we're going to give you an affirmative defense or an expungement. What we're going to do is we're going to give you immunity. We're going to give you a general immunity, which is a different animal than affirmative defense. And I'm not necessarily.
Problem with immunity is that, in fact, prosecutors try not to immunize witnesses when they can because they don't want to tell the jury that there's no accountability for that particular individual. So if you can have them, whether it's a plea agreement or something else,
But
not immunized in that way, that's the better way to go.
Well, with all due respect, I think that's apples and oranges to what we're talking about, which is an affirmative defense and an expungement here. That's a different animal. And in the state codes, the Uniform Criminal Code, there is, right after the definitional section, I believe, I got to go back and look it up, it's been a while, there's a listing of affirmative defenses. And that's why as Mr. Fry has said, most states actually have now incorporated this in that list of affirmative defenses. I do not believe that the same exists at the federal level, that there's a listing of affirmative defenses. And so maybe this fills the void that the states have. I think 49 states have adopted the Uniform Criminal Code. So this might actually fill the void that the federal law has, that the state law doesn't, with affirmative defenses. I love the argument on immunity. I'm not buying it.
Well, if this gentleman will yield,
I will.
are you saying that under provisions of this bill, this would become an affirmative defense at trial? So if a trafficking victim was accused of the crime, was brought to trial for that crime, they could then use this as a defense at trial. It wouldn't be a separate issue later on.
Yes, but the hope would be that since that's now in place, you're not going to have to go forward with all of that. You can move forward with the witness in advance and put the case together against the bigger fish. That's
Well, I'd have no problems with this being a defense of someone who's been wrongly prosecuted, who was a victim of trafficking, was extorted into committing a crime. That should be a defense at trial. It shouldn't be once they're convicted, they can go and then in essentially a non-adversarial forum of a claim that they were being victimized. I'm not going to oppose the bill here in committee, Mr. Chairman, but I'm still trying to resolve that in my own mind.
I yield back.
Gentleman yields back. Gentleman from California is recognized.
Thank you, Mr. Chair. I am very glad we're taking up this important legislation today on a bipartisan basis, and I urge its passage. Justice means protecting victims and punishing perpetrators, but unfortunately, victims of human trafficking are sometimes themselves punished instead. Human trafficking is a heinous crime, with men, women, and children being abducted and sold, being forced to toil in bleak conditions, or subjected to sexual slavery. And when traffickers force their victims to commit crimes as part of the illegal operation, this deters victims from escaping and turning their traffickers in, since the victims have been forced into criminal lives themselves and feel they have nowhere to turn. As has been noted, there is no protection in federal law for these victims when they're forced to be part of these nonviolent crimes. This bill removes the leverage traffickers have over their victims by vacating convictions and expunging criminal records for nonviolent offenses that were committed by victims at the order of their traffickers or under duress. This will ensure that victims do not end up in jail alongside their own kidnappers. They will be able to re-enter society, get jobs, resume normal lives, turn their lives around. Mr. Speaker, Mr. Chair, it's vitally important that we do everything we can to end the horror of human trafficking, and that includes supporting victims in every way we can. This bill is an important step in the right direction. I urge its immediate passage, and I hope that the Senate will act on it quickly as well. I yield back.
Gentleman yields back. The chair recognizes the gentleman from South Carolina.
Mr. Chairman, I request unanimous consent to add into the record a statement from the bill's co-sponsor, Ted Lieu. He couldn't be here today, but he wanted a statement for the record.
Without objection. Question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 9151, the Protecting American Industry and Labor from International Trade Crimes Act of 2024 for purpose of markup. Move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 9151.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from California, Mr. Issa, for an opening statement.
Thank you, Mr. Chairman. U.S. trade policy is a vital tool to protect American businesses and workers, ensure American competitiveness, and achieve foreign policy objectives. The U.S. trade policy, to be effective, has to be resolute and enforceable, and the implementing laws must be in place. Today's criminal enterprises and bad actors, predominantly based in China, are breaking U.S. trade laws with impunity. Over the past decade, law enforcement has identified hundreds of instances of trade fraud, most of which originates in China. Not only does this fraud deprive us of over $1 billion in anti-dumping and countervailing duties, but it seriously undermines trade policy. In just 1 year, fiscal year 2023, U.S. authorities seized over $2.7 billion worth of counterfeit goods from China. Those seizures reflect billions of dollars of stolen from U.S. businesses and workers, which undermines the trade policies designed to protect them. We must do more to punish the criminals that are breaking our trade laws and seriously harming our economy to the tune of billions of dollars every year. Only then can we stop the bleeding and protect our citizens to ensure continued credibility of U.S. trade policy. H.R. 9151 will set up such a structure needed at the Department of Justice and go after criminals who perpetrate trade crimes. These crimes include trade fraud, tariff and duty evasion, illegal smuggling, trade-based money laundering, trafficking, and counterfeit goods, and more. The bill will enable the Department of Justice to dedicate specialized personnel to investigate and prosecute the perpetrators of these crimes. As more crimes are investigated, more criminals are caught, and more precautions can be put into place, these criminals in jail will send a message to others, including our adversaries in China, that they no longer operate with impunity. Mr. Chairman, I certainly understand that the Communist Party, the CCP, will not quit at this, and that many of the foreign actors cannot easily be reached by the Department of Justice. But let us just be clear, many people who perpetrate crimes in China also venture into the United States and to our allies. Indictments and prosecution will not be limited to American citizens, but in fact will restrict the unwarranted and continued freedom that these perpetrators have. And on that, I yield back.
Gentleman yields back. The chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 9151 would create a task force within the Department of Justice to increase the prosecution of trade-related crimes. Although DOJ has already has dedicated personnel to enforce laws protecting Americans from illegal products, limited funding prevents prosecutors from doing more. As introduced, the legislation before us today would expand trade crime enforcement in the United States by creating and funding a program with new positions for criminal trial attorneys and associated support personnel to conduct trade-related crime investigations and prosecutions. Americans are protected from trade crimes by a patchwork of national security laws, including the Tariff Act of 1930, the Toxic Substances Control Act, and many others. These statutes protect against a wide variety of crimes that impact the health, safety, and financial security of Americans, from the importation of counterfeit goods to the commission of trade secret theft through economic espionage. We have all heard stories about the most egregious cases: exploding counterfeit batteries that cause e-cigarettes to maim users, computer chips equipped with spyware in our product stream that endanger military secrets, handbags made with forced Uyghur labor passed off as fair trade materials. These are terrible outcomes with clear victims, and United States law enforcement should ensure these cases never happen again. Other trade crimes may not have a clear victim or a defined perpetrator, but they are equally pernicious. For example, cyber intrusions can risk a company's trade secrets without their knowledge. They may never become aware of the data leak, but a foreign competitor can use the intellectual property to unfairly compete with the targeted company. Counterfeit products that look identical to a brand's trademark can cause irreparable damage to a small business or designer. Victims can suffer reputational damage, lose the opportunity to break into a specific market, and otherwise lose revenue that would have gone to them. Over the last year, IP Subcommittee Chairman Issa and Ranking Member Johnson have held multiple bipartisan subcommittee hearings regarding the IP and trade crimes threat posed by the Chinese government. Witnesses have testified about the flood of trade crimes and the inability of our government's limited resources to prevent, detect, and prosecute violations of the law. The deluge of counterfeits and the unique way trade crimes are perpetrated have made it increasingly difficult for prosecutors at the Department of Justice to enforce our laws. This legislation, as drafted, would help the government prevent trade loss by creating and funding a task force to identify, investigate, and prosecute crimes that hurt Americans in every industry. This legislation has been a bipartisan effort. I thank my colleagues on both sides of the aisle on the Select Committee on China, the Appropriations Committee, and the Judiciary Committee for creating carefully negotiated legislation that, if properly funded, would help the Department of Justice better pursue their objectives. Even after this bill becomes law, the program we are voting for today has an uncertain future. Without funding, the myriad investigators, prosecutors, and support staff envisioned for the task force will never be hired. You cannot increase trade crime enforcement without increasing the number of prosecutors working on the issue. And you cannot increase the number of staff handling trade crimes without more funding. Over and over again, I have heard my colleagues across the aisle call for Congress to defund agencies like the Department of Justice. Yet in the same breath, they ask them to do more to protect Americans. You cannot withhold funding from agencies that keep us safe and then act surprised when they do not have enough people to do the job. I sincerely hope we commit dedicated appropriations to this program and all aspects of DOJ in the days and months ahead. Republicans and Democrats on this committee do not agree on much, but the bipartisan work to promote intellectual property enforcement and protect American consumers has been a rare source of collaboration across the aisle during the 118th Congress. I support this legislation. I encourage my colleagues to do the same, and I yield back the balance of my time.
Gentleman yields back. The chair now recognizes the gentleman from California to offer an amendment in the nature of a substitute.
Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purpose of the amendment. The chair now recognizes the gentleman from California to explain the amendment.
Chairman, much of the amendment is, in fact, a technical corrections to make it conforming, and a small portion of it reflects this constant bipartisan work we did to scrub it and make it right. There are no substantive changes that would affect the underlying bill, but rather be mostly technical in nature. And I urge support for the underlying amendment.
The gentleman yields back. Gentleman from Florida is recognized. Gentlelady from North Carolina is recognized. Then we'll come to the gentleman from Florida.
Okay. Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
I am glad to support this bill protecting American industry and labor from International Trade Crimes Act of 2024. This bill is a critical step towards strengthening our enforcement against trade-related crimes that hurt American businesses, workers, and consumers. In my home state of North Carolina, we've seen the damaging effects of foreign companies violating trade laws, committing fraud, and evading duties, resulting in lost jobs and the closure of businesses that have long supported our communities. By creating a dedicated unit within the Department of Justice to prosecute trade-related crimes, this legislation will help ensure that foreign bad actors are held accountable for actions that undermine our economy and violate the rules of fair trade. It will also bolster coordination with federal agencies like Homeland Security investigations and U.S. Customs and Border Protection, providing them with the resources and expertise needed to combat trade crimes. This is a bipartisan, common-sense approach to protecting American jobs and ensuring that if you trade with America, you must follow the rules. I urge my colleagues to support this vital legislation for the protection of our economy and our workers. Thank you, and I yield back.
Gentlelady yields back. Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman's recognized.
Thank you. So I get the idea behind this. I understand it's a serious problem, ostensibly aimed primarily at China. But what this thing does is basically creates a new sub-agency within DOJ, a task force or a named program or other similar structure. So I'm trying to understand what that might look like. So I'm wondering how big that might begin and how big it will end up, because it's not limited. It's not defined in here, anywhere in here. But it does specifically say that you're going to create a new structure, a complete new structure within the Department of Justice, which has not won much of my confidence lately, just to say. But then I want to ask, or just suggest through self-questioning, is if you look in Section 4, A2C. This is when, as I was going through the different statutory crimes that these folks are going to be able to investigate. This one is a conspiracy to commit crime against the United States. First of all, you have a conspiracy to commit a crime against the United States. Since we had all these other crimes, I think there are 21 other crimes that were listed here, I was wondering what in the world a crime against the United States would look like, since you've defined fraud and tariff and weight standard violations. What is this more generic crime? I couldn't find it. I was looking. And then the last point I would make is under Section 4A1, it specifically allows the Attorney General to increase the capabilities and capacity of the Criminal Division of the Department of Justice to prosecute trade-related crimes. There's no limitation here, and thus, again, I'm wondering what this all might end up looking like. Do we want to see these crimes prosecuted? Yes. And since ostensibly it's China, I thought we've done other pieces of legislation over the last 2 years or so where we have actually iterated a series of nations or a limiting list of nations saying we're going to focus on these. But this task force certainly seems broader and increases the capacity and the capability. In some of these statutes don't even have mens rea requirements. They're very broad. And having watched DOJ become weaponized in the last, since I've been here watching, this becomes a bit of a struggle for me. I'm trying to work wrap my head around some of this stuff, and some is that, Mr. Chairman, I'll yield back.
The gentleman yields back. The gentleman from California is recognized. Florida is recognized.
Yeah, thank you, Mr. Chairman. And I share my colleague from Arizona's concerns. I'm old enough to remember just a few hours ago when Marcus Allen was sitting at the table directly in front of us telling us that the DOJ was mistreating whistleblowers. And it wasn't just Mr. Allen, it was also the Inspector General, Mr. Horowitz. And I made the point then that the way to deal with this was to fence resources away from the DOJ until they did right by these whistleblowers. And astonishingly, a few hours later, we're here building a new $20 million tool for the Department of Justice. And while I certainly agree that with Mr. Issa that there are problems that arise from China's trade crimes, I'm left wondering why there has to be a new task force and a new funding structure, and why we couldn't just accommodate this within the normal work of the DOJ. I'd yield to the gentleman from California to maybe help me through it.
I thank the gentleman, and your point, although I don't see the $20 million portion, that's out of existing funds. So, but I do share with the gentleman that we are prioritizing not just China, although the substantial portions, more than 80%, can be directly related, but because China, through surrogates and other countries and some other actors, also participate in these kinds of crimes, it is appropriate not to name China as the only place. Having said that, we do have a problem at DOJ, and the problem at DOJ is we do not require them to do enough in specific areas, but rather we allow them to move their dollars wherever they choose. And as the gentleman from Florida has seen time and time again, they often move it to where they have political priorities, including the weaponization. In this case, the target is clear. It is criminal activities from outside the United States that come to our shores, in which the FBI and the Department of Justice uniquely do have the authority. And I think the important thing, and that I'm sure the gentleman shares with me, many of the things done by Department of Justice belong in the states, or at least the states also have redundant capability. This is something where the reach of the Department of Justice overseas uniquely says this should be a federal priority. And I thank the gentleman for yielding.
No, thank you. I greatly appreciate the explanation. It was very helpful. Would some of this foreign activity, these trade crimes, include the reflagging dynamic we've seen where China will, send widget to random country where we have a free trade agreement. That widget will then take upon it a sticker or some nominal modification and then be reflagged so as to avoid tariffs? Is that the type of thing this task force will
If the
target?
gentleman would
I
yield.
will.
You couldn't be more right that under the USMCA, we, the last administration, raised the requirement for Mexican, for example, content, and yet every day products that have really not changed other than a sticker being removed or maybe put in a box are being shipped over our border. That type of fraud clearly should be investigated, and the reach of Department of Justice would be quick and certain against our partners just to our south.
And finally, I would ask, I've always wondered, do we estimate how much we lose in the reflagging enterprise? Because I think it happens relatively frequently.
There's no question at all, the gentleman further yield, that there is, in fact, massive tariffs. We're estimating over $1 billion. And of course, there are more than several $1 billion of seizures per year, which shows you that that is obviously only the tip of the iceberg. If you seize $1 billion worth of goods, there have to be $20 or $30 billion in order to be able to lose that and still be in the business. So you're absolutely right. This is of large proportion, and one of the reasons that moving within their budget $20 million seemed to be but a down payment on a very good investment.
Thank the gentleman for his indulgence and yield back.
Gentleman yields back. Gentleman from Maryland is recognized.
Thank you, Mr. Chairman. And to my colleague from Florida, I did want to just chime in support of the Mr. Isa's comments. My thought only on sort of aggregating the prosecutors together in one site was the concern that if you don't do that, I think there's 98 U.S. attorneys' offices across the country. And so if you spread them out all over the place, two things happen. One, they don't get the sort of expertise and focus developed to get on these crimes. But the other concern I had, because I saw this happen, was they get sent to, I don't know, the fill in the blank district of, state X, and they get absorbed into doing other things. And so the concern I had was that you'd lose the focus at DOJ on trade-related crimes if you spread them out too much. So that was the reason I thought it was a good idea. I take the gentleman's point, but I think that it's better if you aggregate it in this way. And the other upside to that is when the local prosecutors know there's an expert team, I guess this will be in Washington, and they're in, let's say, California, and an issue pops up, they know where to call, as opposed to trying to, figure out, well, who's the expert on this? Well, they know they can call that unit in D.C. and get help on that front. And if the case goes forward to trial, they'll bring out the experts from D.C. to co-chair the trial to get it done. So that was my thinking on it, and I want to commend the chair to Chair Issa for moving this forward. And with that, I yield back.
Gentleman yields back. Gentleman from California is recognized.
I look to Mr. Ice to perhaps educate me on this subject. It involves the operation of the de minimis exemption for daily packages under $800. The committee analysis notes the administration has just recently announced that it intends to promulgate a rule that would effectively remove this exemption for packages under $800, not completely, but largely. Does this mean that these packages would now be subject to the enforcement provisions under this bill? My concern is that we end up, two things. Number one, we end up spending thousands and thousands of dollars to enforce a few dozen dollars of tariff. And with 4 million packages a day under this exemption, obviously there's not enough money in the world to prosecute those 4 million a day packages. Doesn't that just give the Department of Justice enormous discretion to go after people they don't like?
The gentleman would yield. I share with you the concern. The good news is that the vast majority of those packages will never be looked at, but those that are, because the waiver is gone, will pay for themselves both in de minimis tariffs, but tariffs that even on $80 or $90 would add up. There are two things that I'm sure the gentleman knows being a Californian. One is that the claim that you're under $800 and the opening of the package often are very different, that you find much more value inside than was declared. The other thing is this has been a loophole, the claim of de minimis has been a loophole in which 10 Louis Vuitton fakes are often inside that waived package. And I'm sure they're worth less than $800 considering they're fakes, but this would allow border or customs to be able to seize these. In most cases, candidly, there'll be no prosecution. They'll simply lose the asset. So it will keep the customs people very busy keeping these clones out, recognizing that in most cases, it's not going to rise to Department of Justice because they're not going to prosecute, a dozen or less Louis Vuitton fakes. They will, from time to time, get a lead on a U.S. company that is aggregating these, and yes, that will be exactly where we'd like to have it prosecuted. So even though the two are separate, I do think the gentleman makes an extremely good point that what the administration is now promulgating is in fact a rule that's going to increase the work by the customs, at the border, but it also is going to dramatically reduce the loophole that is being exploited, particularly from China.
I just wonder if enforcing trade crimes are the most efficient use of our law enforcement dollars compared with everything else that's going on right now.
If the gentleman would further yield, I share with him that they have to be reserved in how often they do it. But opening packages that just don't smell right, so to speak, and seizing counterfeit goods is something that the customs people have been asking to close this loophole for a long period of time. Again, in most cases, DOJ is not going to touch it, but at least the items will be seized, the shipper will be blacklisted or marked for further scrutiny on future shipments. All of that serves to help America, even if it doesn't produce tariff revenue. As the gentleman knows, I'm also the author of a Shop Safe Act and a number of other bills related to counterfeits and the damage, the actual harm that, for example, counterfeit cosmetic causes to people who use it, or purported drugs that turn out to be dangerous. So all of those are examples where this $800 loophole being modified or closed will help save Americans not just money, but actually their quality of life or their life itself. And I share with the gentleman that we can't have everything prosecuted, and I'm sure we won't.
Gentleman yields back. The question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 9563, the Protecting Americans from Russian Litigation Act of 2024, for purpose of a markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 9563.
Without objection, the bill will be considered as read and open for amendment at any time. The chair now recognizes the gentleman from Texas, Mr. Hunt, for an opening statement.
Thank you, Mr. Chairman. American businesses are being unfairly punished. Russia is pursuing spurious legal action against American companies who have ceased to continue business with Russian entities due to their compliance with the U.S. sanctions and export controls. Whether it's Russia, China, Iran, or any of America's adversaries, we have an obligation to protect America's interest in America's business at home and abroad. U.S. businesses need our help in combating these unfair lawsuits from Russian entities, and that's why I've introduced H.R. 9563, the Protecting Americans from Russian Litigations Act. This bill will protect U.S. business and ensure that they are not unfairly punished for simply complying with U.S. sanctions and export controls. After Russia's invasion of Ukraine in 2022, the United States responded by imposing sanctions and other measures, such as export controls on Russia. Because of these U.S. sanctions, U.S. businesses and other entities that were operating in Russia had contracts with Russian entities and have exited Russia and all business relationships with Russian partners. U.S. businesses are now facing legal action in Russian courts as well as international arbitration. Russian courts can be expected to be hostile to U.S. litigants and refuse to recognize U.S. sanctions as valid. Once a judgment in a Russian court or case or arbitration is won, the Russian party may seek to enforce the judgment in foreign courts, including U.S. and European courts. The European Union includes a clause in its sanctions that bars Russian parties and their agents from obtaining compensation. The United States has no similar provision that would protect U.S. companies. That's why this bill is so important in protecting American companies from unfair litigation. It will provide protection for U.S. companies facing this legal jeopardy by barring civil action against those who are forced to breach a contract because of compliance with U.S. sanctions and export controls. This bill will protect U.S. businesses and ensure that they are not unfairly punished for simply complying with U.S. sanction and export controls. I am proud to co-lead the Protecting Americans from Russian Litigation Act of 2024 with my colleague from Maryland, Mr. Ivey. I'm also honored to have my colleagues, Mr. Nadler, Mr. Issa, Mr. Fitzgerald, Mr. Johnson, and Mrs. Lee to join us as original co-sponsors for this bill. This bill proves that even in divided Congress, we can still work across the aisle in a bipartisan manner to ensure that these matters are most impacted and most important to the American people and to American businesses. Let's protect American businesses from spurious litigation from Russia and from any other country that may seek to unfairly harm American companies for complying with U.S. sanctions and export controls. With that, I yield back.
Gentleman yields back. The chair asks unanimous consent that Mr. Nadler, the ranking member's opening statement, be entered into the record. Without objection, it will be entered in the record. And without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Maryland.
Thank you, Mr. Chairman. And I've been notified that votes have been called, so we'll keep that in mind. And also, I'll say this too. I think the gentleman from Texas has done an outstanding job of laying out the case for this piece of legislation. The only point I would add, I think, is that that this bill does not interfere with or limit the rights, remedies, or causes of action available to victims of international terrorism, which I think is an important piece. But other than that, I think the gentleman from Texas really laid out all the key points, and I want to thank the other co-sponsors. I want to thank the chair for bringing the bill forward, and I urge my colleagues to support this bill. And I yield back.
Gentleman yields back. The question on favorably reporting the bill. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill without objection, all technical and the staff is authorized to make technical and conforming changes. And that concludes today's business. We have votes on the floor. I wish everyone a good break, and we'll see you after the election.